Hello, this is Dane Cialino of the Louisiana Legal Ethics blog and Loyola University New Orleans College of Law. In this brief video, I want to discuss some of the differences and similarities between the American Bar Association Model Rules of Professional Conduct and the Louisiana Rules of Professional Conduct. I'm of course going to stick mostly with the differences, but I get this question a lot, and it's really hard to sum this up in about a minute or two. So in this brief video, I want to hit the most important differences. Rule 1.1, of course, this is the basic competence obligation. I think the most important rule of all of the rules, because if you're going to just have one rule, you'd want competent lawyers for clients. The ABA has that basic obligation. And of course, so do the Louisiana Rules of Professional Conduct. The Louisiana rules, however, have an additional obligation that lawyers have to get CLE in order to comply with the rules. And of course, all this does is give the court disciplinary authority to impose discipline for a lawyer who doesn't get, a Louisiana lawyer who doesn't get her 12.5 hours of CLE each year. The Louisiana rules also impose an obligation to register every year with the Bar Association, to pay dues, to notify the Bar Association regarding any changes in your address, and also to notify the bar about the location of your trust account. The reason for that, because if you bounce a check in your trust account in Louisiana, the bank is obligated to send the the Office of Disciplinary Counsel, notice of that overdraft so that ODC can investigate further. Rule 1.4. This, of course, is the basic communication obligation, and you could sum it up essentially by saying lawyers have an obligation to engage in reasonable communication with their clients. Louisiana, too, of course, has that basic obligation, but the Louisiana rule also has provisions that require a Louisiana lawyer who provides financial assistance to his clients, for example, providing living expenses, those sorts of things, to give them information, the client's information about the repayment obligation, about the interest rate, and the legal and ethical implications, or actually restrictions, on what a lawyer can and can't do in connection with providing legal or living expenses to a client. Why does Louisiana have this special rule? Well, because the model rules, as we'll see in a subsequent slide, don't allow the types of financial assistance that Louisiana does. So this just essentially goes hand in glove with the ability of Louisiana lawyers to provide living expenses to clients. This requires them to notify and communicate with their clients about those obligations, or about those financial bits of finance. Rule 1.5, again, the basic fee rule. Louisiana has the basic Rule 1.5a that all fees must be reasonable, of course. 1.5c, of course, regulates contingent fees. What's different in Louisiana? Well, under the ABA rule, you've got to have a signed contingent fee agreement. Same in Louisiana, but in Louisiana, the Louisiana lawyer has to give the client a copy of the signed fee contract, something that the ABA rule doesn't require. The ABA rule, Rule 1.5e, allows sharing of fees between lawyers in different firms. Now, of course, that rule doesn't apply if the lawyers who are sharing the fee are partners or associates or of counsel in the same firm. Louisiana allows fee sharing, but the rule is a little bit more specific. And these specifics were added back in the 2004 time frame because Louisiana wanted to cut back on referral fees, or what in essence are referral fees. So what did Louisiana do? Well, in Louisiana, you can share fees, but only if the client agrees to the representation by all of the lawyers who are sharing the fees. This makes it very clear that when you are sharing a fee, you are also representing the client. So you can't just pass the client off to another lawyer and then sit back and collect another fee. you have to, quote, represent that client. In addition, you have to provide some meaningful legal services. Now, note the particular word used, meaningful legal services. It's not substantial legal services. And the committee that drafted this language was very careful to use meaningful, which means that a Louisiana lawyer just has to do something, well, meaningful. You could be holding the client's hand, acting as a conduit for information, maybe just handling one aspect of the case. It doesn't mean a lot of work, it just means something that matters, and it also means legal services. There is no guidance in the ABA model rules about how to handle funds paid in advance of services, like, for example, how to handle a general retainer, how to handle a fixed fee. Louisiana has a particular rule, Rule 1.5F, that provides detailed guidance regarding depositing fees received in advance of services. Actually, quite a very helpful rule for Louisiana lawyers. So if you get a fixed fee and you ask yourself, well, what account do I put this in? Do I put it in the operating account? Do I put it in the trust account? I get a general retainer. Which account do I put it in? You look to 1.5F and it'll tell you. Spoiler alert, if you get, for example, an advance on hourly fees to be earned through work done later, those go in your trust account. Why? Because it's not your money. You haven't earned it yet. Once you work and you earn that money, then you can move it from your trust account to your operating account. Rule 1.8. Remember, this is the catch-all rule on concurrent conflicts of interest that arise in particular situations. The ABA model rule permits gifts from, quote, other persons with a close relationship. That is, there's nothing wrong with a lawyer saying to his father, or maybe his live-in close girlfriend, saying, hey, why don't you give me something in your will, I'll give you something in mine, for example. And nothing would prohibit that because of the familial relationship with the father and the, quote, close personal relationship with another person. Louisiana permits gifts only from those who are related, and related is defined as spouse, child, grandchild, parent, or grandparent. And historically, the reason for this is that Louisiana was traditionally a little leery and wary of non-traditional relationships, let's say. Of course, Louisiana doesn't recognize common law marriages, and Louisiana for a very long time didn't represent or recognize same-sex relationships. Well, of course, in the wake of Obergefell versus Hodges in 2015, those relationships are constitutionally required to be recognized in Louisiana. So part of the rationale for this difference is gone. But nonetheless, in Louisiana, you must be related in order for this rule to apply. The ABA Model Rule 1.8 prohibits most financial assistance to clients other than litigation-related expenses. This is a huge difference. In the ABA model system, if a client comes to a lawyer and says, would you please lend me $1,000, I need to pay my rent this month, I lost my job. A lawyer can't do it. A lawyer, of course, can advance litigation-related expenses, things like deposition costs, medical expenses, those sorts of things, but not living expenses. In contrast, Louisiana's rules expressly permit financial assistance to a client in, quote, necessitous circumstances, if it's necessary for the client to maintain the cause of action. It can't be used as an inducement to get the representation. Why does Louisiana do this? Well, Louisiana is an outlier here. Louisiana lawyers can give loans and financial assistance to their clients. And this is the result of a Louisiana Supreme Court opinion from the 70s written by then Justice Dennis, who said that there's a constitutional right baked into the Louisiana Constitution for this. Otherwise, people litigants would not be able to continue their lawsuits and would have to settle cheap. Now, many people question the constitutional footing for this interpretation of the Louisiana Constitution. Some would say Justice Dennis just made it up, but there it is. It's part of Louisiana state constitutional law, so it's this obligation or this ability, it's not an obligation, this ability that Louisiana lawyers have to provide financial assistance to their clients is now, since roughly 2004, baked in to Rule 1.8. The ABA model rules, of course, Model Rule 1.8J has a prophylactic across-the-board per se prohibition on having sex with clients. Under the ABA model rule, it's okay to turn your spouse or significant other into a client, but you can't turn your significant other, you can't turn your client into a significant other. You can't start a sexual relationship while someone is merely your client. Louisiana, however, didn't adopt this rule. And this was kind of peculiar, I was on this committee, to me, because the Office of the Disciplinary Counsel didn't want it. And by a close vote, I believe it was something along the lines of 5-4 back in 2004, the Ethics 2000 Committee of the Louisiana State Bar Association declined to recommend adoption of the model rule to the Louisiana Supreme Court. And it was not recommended. So where does this leave us? Does that mean that lawyers in Louisiana are free to have sex with their clients? Absolutely not. What it means is that regulation of sex with clients is not done under Rule 1.8J, but rather is done under the general conflicts rules, more particularly Rule 1.7. A2 says that a lawyer can't represent a client if the lawyer would be materially limited by a personal interest conflict. Rule 2.1 says that a lawyer has got to be essentially professionally independent and give independent advice, unimpaired advice to a client. So that's what the Louisiana Office of Disciplinary Counsel does. It regulates sex with clients and fairly commonly, several cases a year, several disciplinary matters arise out of sex with clients. So Louisiana lawyers are disciplined for sex with clients. It's just not under a per se rule as under the model rules. The ABA model rules require informed consent from a third party to pay. So if you're getting your bills, your legal bills paid by a third party, then you have to get from the client permission. Now, generally the clients care if somebody's mother is paying for their legal defense. No, I mean, if you want to pay my bills, fine. Louisiana allows it just as well. Again, you need generally informed consent before you can do it. However, if you've got an insurance company who's paying for your legal bills, which is the case when you get in a car wreck, of course, then you don't have to ask the client for permission to accept payment from the insurance company. The client has already paid with their premium dollar the insurance company to provide this lawyer. So when the insurance company provides the lawyer after they've been in a, say, car wreck, it's not a surprise to them. In fact, it's an expectation that the lawyer is going to be paid for by the insurance company. So again, not a big difference, but just one worth noting. The Louisiana rules expressly allow a lawyer to obtain a power of attorney to endorse or negotiate an instrument, but not to settle a matter. So, for example, in your engagement agreement with a client, you're free to put into the engagement agreement, for example, that you can endorse checks, you can sign releases, but only after you get express approval from your client. And one thing that the Louisiana Office of Disciplinary Counsel really does not like to see in an engagement agreement is a provision that says that a lawyer can settle a case. That's prohibited. Authority to settle, no. Authority to endorse, sign documents, that's expressly allowed. Rule 1.10, this is the basic rule on imputation of conflicts. The ABA says, has essentially a migratory lawyer safe harbor that facilitates lawyers moving from one firm to another firm. And in order to facilitate that, the ABA model rules do not impute a conflict of interest arising under 1.9A or B. This is the kind of former client or former firm client situation. If a lateral change of firms, if a lawyer changes from one firm to another, and the new firm implicates screening, notice, and certification. So what does that mean? Well, it means if you're working at firm A and you decide to move to firm B, but you leave your clients behind, then when you get to firm B, even if firm B is adverse to your former client or your firm's former client, that conflict that you have that would prohibit you from suing your former client on the same or substantially related matter is not going to be imputed to everyone else at the firm if the new firm sets up screening, notifies your client, and certifies to the parties, not just your client, but to the firm's client, and certifies that this screen is in place. Louisiana, no screening is permitted here for lateral change of firms. Now, Louisiana allows screening in other contexts with government lawyers, former judges, etc. It's also with prospective clients, but not for lateral hires, not for the migratory lawyer situation. So in Louisiana, if you used to represent a client, you leave that client behind, go to a new firm, that new firm is suing the client, your former client, on the same or substantially related matter. What does that mean? It means that you, not only are you disqualified from handling that matter, your whole firm is disqualified by imputation. Something that conceivably could hamper Louisiana lawyers' ability to make lateral transfers. Rule 1.15. This is the general rule on trust accounting and handling client property. Louisiana, of course, has got it. But Louisiana's rules are much more detailed. Louisiana requires trust accounts to be at a bank or similar institution, like a federal credit union. Requires handling of funds consistent with Rule 1.5F, something that we've previously discussed. It prohibits debit card withdrawals and cash withdrawals from the trust account, again, because we want to just track where all the money coming out of the trust account is going. Our Louisiana rule also addresses a lawyer's obligations when a third party claims a, quote, interest in funds in the lawyer's possession. And by interest in funds, that's essentially when a third person, like a doctor maybe, has a lien. The lawyer has promised to pay the doctor out of the proceeds of a settlement. The settlement comes in, and now the doctor has a lien. The doctor may have a lien as a matter of law anyway. The lawyer, if he knows about that lien, and he's got to respect it. Even if the client says, don't pay that doctor, the lawyer has an obligation under Rule 1.15 to pay the doctor. So again, very important rule. A lot of disciplinary activity happens in this area because sometimes lawyers don't pay third parties when they get a settlement. And that leads to serious disciplinary consequences because lawyers have an obligation under this rule to satisfy those liens about which they are aware. And if they don't, they suffer the disciplinary consequences. It also, 1.15, Louisiana's version, addresses disposition of unidentified funds and also funds with clients who can't be located. So if you have money in your trust account and you don't know who the money belongs to, within 2 years you have to give it to the Louisiana State Bar Foundation. Same, if you know who the funds belong to, but you can't find the client, after a year, you have to give those funds to the Louisiana Bar Foundation. Now, if later on you find out where the person was or who the funds belong to, you can claw the money back from the Bar Foundation. But this really was a useful change that helped or directed lawyers what to do with these funds that sometimes for decades had been sitting in their accounts. Rule 1.16, this is the basic rule on what you do as a lawyer on termination of the representation. And of course, Louisiana's 1.16 has that basic rule as well. But Louisiana's got a rule dealing with the file. And this is a very common issue that comes up when a lawyer has been discharged and the client has gone on to get another lawyer. The client says, please send my file to my new lawyer. Well, most lawyers comply, but sometimes lawyers are difficult and they say, look, you owe me money, or I don't want to send the file, you have to pay for the copying. Louisiana's Rule 1.16 makes it very clear that that is not permissible, that you have to give the, quote, entire file to the former client upon, or the former client's new lawyer upon receiving a, quote, written request. Very important, lawyers in Louisiana cannot hold files hostage after they've been terminated. And again, you can't condition release. You can make a copy, but you can't charge the client for the copy. If you think that it's for some reason unjust for you to pay, you can work that out in court, but you have to give the original file to the client and pay for your own copy and try to get those copying costs back later if there's good cause. Rule 1.17. This is the rule that allows Louisiana lawyers to sell a law practice. And Louisiana has a similar rule, but it permits lawyers, only lawyers who are not suspended or disbarred, to sell their law practices. And it specifies the types of notice that must be given to clients, really including such archaic things as paper certified mail notice. I didn't think that was a good idea to bake that into the rule, but the Louisiana Supreme Court did. Rule 3.8. This is the rule that tells prosecutors in the model rule that they must disclose evidence known to them to be exculpatory or mitigating. In Louisiana, prosecutors must disclose only, quote, material exculpatory evidence known to them. Material, which means if there's some evidence that some defense lawyer might be able to use on cross-examination, might tend to exculpate a defendant, but it's not going to change the result. In Louisiana, the prosecutor is not subject to discipline for failing to turn that over. Again, it just brings the Seastrunk opinion, which I actually represented Mr. Seastrunk in that matter. The Seastrunk opinion simply brought the rules of conduct and the disciplinary standards into line with the constitutional standards under Brady. So now, if a lawyer violates Brady, the lawyer is subject to discipline. If the lawyer doesn't violate Brady, the lawyer is not subject to discipline. The Louisiana rules also requires lawyers to turn over not only evidence that they know is material and exculpatory or mitigating, but that they should know. Again, a little bit of a lesser or actually a greater obligation on Louisiana lawyers because they are subject to discipline for their negligent Brady violation. The ABA model rules have provisions that aren't in the Louisiana rules that deal with what happens when a prosecutor comes into possession of information suggesting that there's an innocent person in jail. And there are different standards for whether the person is in their jurisdiction, etc. Louisiana doesn't have any obligation in this regard. The Louisiana District Attorneys Association was not interested in the Louisiana Supreme Court adopting these standards, and Louisiana Supreme Court essentially didn't decide to adopt that. So in Louisiana, we don't have these obligations with regard to innocent defendants. Rule 4.2. This is the rule that says a lawyer shall not communicate with a person represented by counsel. Louisiana, of course, has the same rule. If I know another person is represented by a lawyer, I can't just go up to them and approach them and discuss the case. So the basic rule is the same. Louisiana, however, has detailed rules that deal with what happens if you want to contact a person of a represented, or who's a constituent of a represented organization. So, for example, suppose you're suing Rouse's Supermarket for a slip and fall. You're a plaintiff's lawyer. Can you go over to Rouse's and interview the store stocking clerk who saw the accident? How about the safety manager? How about the president of Rouse's? Well, the Louisiana rule is not different from the model rule, but the Louisiana rule has taken what is in the comments to the model rule 4.2 and moved those principles up into the black letter of Louisiana Rule 4.2b. So, again, not different standards, but clarified and express standards. So a Louisiana lawyer cannot communicate with a present constituent of a represented organization, which first of all tells you that former constituents aren't covered by this. A former employee is fair game. You can go talk to him all you want, even though his former employer is represented by counsel. But assuming you want to talk to somebody who's presently working for or a constituent of a represented organization, you can talk to everybody in that organization except the following three classes of constituents. Number one, someone who supervises, directs, or regularly consults with the organization's lawyer. Someone who has authority to obligate the organization with regard to the matter, like, for example, someone who has the authority to settle the matter. Or the tortfeasor, that is, somebody who's committed an act or omission relating to the matter that may be imputed to the organization. So in my hypothetical lawsuit against Rouse's, you could talk to some stock clerk who happened to be putting things on the shelf when the slip and fall occurred. But you can't talk to the person who actually dropped the banana peel or failed to find the banana peel, or the president or risk manager who, for example, might be able to settle the matter, or anyone else who regularly consults with the lawyer. But other than that, everyone else is fair game for the lawyer to talk to. Rule 4.4. This is the rule that deals with missent faxes. Under the ABA Model Rule 4.4, all you have to do is if somebody sends you an email or a fax and you look at it and you go, geez, this wasn't intended for me. This was intended for the sender's client, if saying it's another lawyer. Does that happen? You bet it happens. Well, what do you do under the ABA Model Rules? All you have to do is inform the sender that you received this. That's it. You don't have to do anything else. If they want to claw that document back from you, well, they can do whatever they can do under the rules of procedure and substantive law. But as an ethical matter, the only thing you have to do as the inadvertent recipient is to notify the sender that you received the inadvertently sent document. How does Louisiana differ? Well, in Louisiana, the lawyer not only has to notify the sender that she got the document, but also she's got to kind of avert her eyes and not look at the document and then return it to the sender or destroy it if it's ESI, electronically sent information. That's the rule. It's a little goofy. I was on the committee that adopted this rule. I didn't like it because I think it imposes a very difficult obligation. Lawyers often might just continue reading to the bottom. Why? Just because they want to make sure it's not sent for them. But this requires lawyers to avert their eyes and stop reading, destroy the document if it's ESI, and notify the sender. Now, can the Louisiana lawyer try to claw it back? Yes. The Louisiana lawyer has seen it. If a Louisiana lawyer thinks that they are entitled to get the document, they can file whatever paperwork with the court that might be appropriate to get it. And again, this only applies to documents sent by a lawyer to the lawyer who is governed by the rule. So it shows you this Louisiana version of 4.4 is both broader than and narrower than the ABA rule, which is a little anomalous. Rule 5.4. ABA model rule allows a lawyer to share court-awarded legal fees with a nonprofit organization that retained the lawyer. For example, suppose you are a lawyer in private practice and the ACLU is an organization that you support, and they call you and say, hey, would you mind handling a school prayer case for us? You go, sure, I'll do it. And you handle it, and you get a fee award at the end, but you want to just do pro bono work. Nonetheless, you make a fee award. The court can award the fees, and you can give them, share them with the ACLU. Give all or part of them to the ACLU because it's a nonprofit organization that either employed, retained, or recommended you. That's omitted from the Louisiana rules. I don't know why, but it's just not there. Rule 5.5, this is the rule on multi-jurisdictional practice, allows you to temporarily practice in other jurisdictions. The ABA, and of course Louisiana's got comparable provisions. The ABA rule permits practice by an in-house lawyer who is an employee of a client. Louisiana does too, but it's under a separate rule structure that's in Louisiana Supreme Court Rule 17, Section 14. Again, you can do it. It's just regulated a little bit more granularly and in a different place. The Louisiana rules prohibit a Louisiana lawyer from employing a disbarred lawyer. This isn't in the ABA rules. So for example, suppose you're running a personal injury shop and you decide that you would like to have a paralegal help you with your practice, and that paralegal happens to be a disbarred or permanently disbarred lawyer. Can you do it? Nope. Under no circumstances. You can't even, as a Louisiana lawyer, hire a disbarred lawyer to be a janitor or file clerk at your office. Why? Well, because the Office of Disciplinary Counsel had seen some pretty egregious cases with disbarred lawyers acting as paralegals and really just practicing law again. This rule 5.5 is designed to avoid that. As to suspended lawyers, you can hire a suspended lawyer. However, you got to register that employment as the employing lawyer. You have to register that with the Office of Disciplinary Counsel. Essentially tell ODC that you've hired this person, and then ODC can keep an eye on you. Rule 5.7, this addresses obligations of lawyers providing law-related services. For example, if you are a tax lawyer, if you also provide financial advice, like what stocks to buy. Can you do that? Yes, but there are certain rules that the ABA has in that regard. Louisiana just doesn't have any regulation in this area. So, can a Louisiana lawyer provide financial advice, accounting services, tax preparation services? How about body shop services if you're a personal injury car accident lawyer? Yes, you can do all that sort of stuff. There aren't any limitations on it and any special regulations that apply. Rule 6.1. This is the rule that says all lawyers should aspire to perform 50 hours of pro bono services a year. Louisiana has that rule as well. Again, it's not really a rule, it's just a hortatory suggestion. But the ABA goes on further to say not only should you aspire to provide those 50 hours of pro bono services every year, but in addition, a lawyer should voluntarily contribute financial support to organizations that help those who need legal services but can't really afford them. It's kind of a forced, it's not forced, because again, this rule, neither in Louisiana nor under the ABA model system, is enforced on pain of discipline. But nonetheless, the suggestion as to voluntary contributions is omitted from the Louisiana rule. So in Louisiana, it's suggested that you should aspire to do 50 hours of pro bono a year, but there's no suggestion that you give money to anyone. Rules 7.1 through 7.10. These are the advertising rules, solicitation rules. The ABA in the mid 20-teens, 2016, 2017 timeframe, substantially revised the ABA model rules to really simplify them. These rules provide minimal regulations in the area of attorney advertising, prohibiting false and misleading communications, but then kind of stopping there. Of course, they also prohibit solicitation, in-person solicitation. Louisiana has some of the worst, most detailed advertising regulations in the country. They're terrible, but there they are. I'm not even going to begin to tell you what they say, because you're going to have to open up a book and read them, and then after you do that, you won't understand what they say. There is a filing and review requirement for lawyer ads. So if you want to run some ads, you have to, at the same time that you run them or before, file copies of the ads with the Louisiana State Bar Association. They look at them, they'll find something wrong with them, they'll nitpick them and then get back to you and tell you what you should change. Do you have to follow the recommendations? No, but if you don't, they turn you into the Office of Disciplinary Counsel. Rule 8.1. Of course, Rule 8.1 prohibits false statements in connection with disciplinary and bar admissions matters. So does Louisiana Rule 8.1. However, this is something that's implicit, or at least constitutionally underlying the ABA Model Rule 8.1, but the Louisiana rule expressly tells Louisiana lawyers that they've got to cooperate with ODC. However, if they openly express a claim of constitutional privilege, they don't have to cooperate. So for example, suppose you get arrested for DWI and there's a prosecution going on against you. ODC might send you a letter, they will send you a letter, and tell you to go see a psychologist for an alcohol and substance abuse evaluation. You can say, no, right now I'm being prosecuted for criminal conduct, and I don't want to have to go and be forced to talk about this because my government, the ODC, is forcing me to do so. So you can say, look, I'm going to take the Fifth. I've got this criminal case pending against me. I'm going to take the Fifth Amendment. And that's okay. ODC then cannot charge you under Rule 8.1 for failing to cooperate. Now, is that also true under the ABA rules? Yeah, because the Constitution applies everywhere in the United States. But the Louisiana rule is good because it expressly gives the lawyer the reminder that the lawyer can assert that constitutional privilege. Rule 8.3. The ABA model rule, under the ABA model rule, if you see another lawyer commit misconduct, another lawyer has stolen from a client, another lawyer has maybe just missed a deadline, do you have an obligation to turn them in to disciplinary counsel? Well, maybe. It depends on whether or not the lawyer's misconduct raises a, quote, substantial question as to another lawyer's honesty, trustworthiness, or fitness as a lawyer. So if you see another lawyer commit malpractice, you can stop and you can ask yourself, does that lawyer's violation raise a substantial question as to this lawyer's honesty, trustworthiness, or fitness? If you determine the answer is no, then you don't have an obligation to turn the lawyer in. So for example, if you're at the law firm and a lawyer down the hall misses a deadline for discovery. Well, a lot of people make mistakes like that. Do you have to pick up the phone and call the Office of Disciplinary Counsel? No. It's a violation, probably. The lawyer violated 1.3, the rule on diligence, or maybe the 1.1 rule on competence. But no harm, no foul, technical violation, no obligation to report. What about in Louisiana? Well, Louisiana lawyers have limited discretion in this regard. A Louisiana lawyer must report misconduct that raises any question as to another lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. So again, if you see minor misconduct that really raises no question as to that lawyer's honesty, trustworthiness, or fitness, you don't have an obligation in Louisiana to turn the lawyer into disciplinary counsel. But again, more misconduct is reportable in Louisiana under this standard than is reportable under the ABA standard. And that's by design. The Office of Disciplinary Counsel lobbied hard. It used to be that all misconduct was the subject of a reporting obligation. In 2004, when these rules were changed, at least some discretion was given to lawyers not to report misconduct, but not as much discretion as under the ABA model rules. Rule 8.4 brands as misconduct a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. So, under the ABA standard, if you littered or sped or maybe committed some kind of minor offense, yeah, it's a criminal act, but it doesn't reflect on your honesty, trustworthiness, or fitness, so it's not a disciplinary violation under Rule 8.4. Louisiana is very different. Louisiana brands as misconduct any criminal act, and then it goes on in kind of a silly way to say, especially one that reflects adversely on the lawyer's honesty, trustworthiness, or fitness. So any criminal act, doesn't have to be a conviction, doesn't even have to be an arrest. Any criminal act, no matter how minor, can subject a Louisiana lawyer to discipline under Rule 8.4b. ABA Model Rule 8.4 does not prohibit a lawyer from making threats to another lawyer to present criminal or disciplinary charges or against another lawyer's client, although a formal ABA opinion condemns the practice. The Louisiana rules are express in this area. A Louisiana lawyer cannot say to another lawyer, hey, unless you do X, I'm going to turn you into the Office of Disciplinary Counsel. Or you can't say this, if your client doesn't pay this settlement, we're going to turn him into the DA. You can't do that. Now, there's a whole level of nuance here that you can threaten criminal charges if they are closely related to the matter. So, for example, if somebody has stolen some money from an employer, there's nothing inappropriate about the lawyer saying, look, we'll refrain from bringing criminal charges if you settle up the civil conversion matter. You know, again, this is a very delicate area because it implicates extortion law, it implicates Rule 8.4, but here the Louisiana rules do impose an obligation, express obligation that the ABA rules don't. Rule 8.4, the model version, contains broad anti-discrimination and anti-harassment provisions. These provisions were adopted by the ABA in 2018, I believe. Again, prohibiting harassment, prohibiting discrimination. Louisiana doesn't contain comparable rules. The Louisiana Supreme Court has considered it, but has not yet adopted those broad as many states have not adopted those broad anti-harassment and discrimination provisions. All right, well, that ends our very brief discussion about the differences between the ABA model rules and the Louisiana rules. The differences aren't really, in most cases, very significant, but it is important for all lawyers practicing Louisiana to at least understand these differences. And it's not something that you have to know to be admitted to practice in Louisiana. After all, Louisiana ethics rules, professional responsibility standards, are neither tested on the Louisiana bar examination or the MPRE, which of course tests only national and model professional conduct standards. So because of that, there aren't a whole lot of resources for Louisiana lawyers or reasons why they must know these differences. So for all those reasons, I hope this video was helpful.